इससे पहले कि हम कार्यक्रम शुरू करें, आप सबसे अनुरोध है कि 1 मिनट का मौन हम रखेंगे। मणिपुर में जो हिंसा 3 मई से हो रही है, जो जान माल और लोकतंत्र का नुकसान है, उसको याद करते हुए, और उड़ीसा में जो दुर्घटना हुई वहाँ पे जो जाने गई हैं उनको श्रद्धांजलि देते हुए। नीलाभ जी अगर होते तो आज 63 साल के होते, 63 साल के, और अगर आज वो हमारे बीच सशरीर होते तो उधर कहीं किनारे वाली सीट पर बैठकर मंद मंद मुस्कुराते हुए कह रहे होते, चरे वेती चरे वेती, चलते रहो, लड़ते रहो, भिड़ते रहो, कभी न थको, कभी न हार मानो, चरे वेती। हम सब नीलाभ जी को याद करते हुए लगातार तब से चलते जा रहे हैं। आज छठा नीलाभ मेमोरियल लेक्चर सुनने आए आप सभी आदरणीय सम्मानित लोगों, दोस्तों का मैं दिल से आभार व्यक्त करती हूँ, स्वागत करती हूँ। नीलाभ जी को आज के दौर में याद करना बेहद ज़रूरी लगता है, क्योंकि वे जिस तरह की पत्रकारिता करते थे, जिन उसूलों पर बहुत कट्टरता से खड़े हुए थे, बहुत मजबूती से जिस विचारधारा को वो आगे बढ़ाने की अपनी पूरी उम्र में उन्होंने कोशिश की, जिस अमन और मोहब्बत वाले हिंदुस्तान के वे स्वतंत्र नागरिक थे, उस बेसिक कॉन्सेप्ट पर आज बहुत बर्बर और क्रूर हमला है। नीलाभ जी ने जिस जनपक्षधर पत्रकारिता को पूरे जोश खरोश से आगे बढ़ाया, मीडिया के जिन कड़े उसूलों का पालन किया, नफ़रत के खिलाफ प्रेम और सौहार्द को कायम रखने की कोशिश की, पूरी उम्र उसे ज़िंदा रखा, उसे आज ज़िंदा रखना, आगे बढ़ाना बहुत ज़रूरी है। नीलाभ जी नेशनल हेरल्ड समूह के एडिटर इन चीफ थे, उससे पहले आउटलुक हिंदी के संपादक थे, और इस दौरान उनके नेतृत्व में तीखी राजनीतिक दखल वाली स्टोरियां हुई, अनगिनत ग्राउंड रिपोर्ट्स हुई, सत्ता को जो दबाव है उसे किस तरह से, किस महीन ढंग से धता बता के नए पुराने पत्रकारों को ट्रेन किया जा सकता है, इसकी जीती जागती मिसाल रहे नीलाभ मिश्र। हम सबको इस बात की टीस हमेशा रहेगी कि नीलाभ जी को बहुत कम समय मिला, लेकिन इतने कम समय में वे बहुत लंबी लकीर खींच गए। नीलाभ जी बिहार, जहाँ उनका जन्म हुआ, जहाँ का वो अपने को मानते थे, उतने ही वे राजस्थान के थे। राजस्थान जो लंबे समय तक उनकी कर्मभूमि रही, उनकी लाइफ पार्टनर, संघर्षों की साथी कविता श्रीवास्तव उनको वहाँ मिली। फिर दिल्ली तो दिल्ली है। वे हिंदी के विरले संपादक थे जिनकी महारत अंग्रेज़ी में भी उतनी ही थी। अंग्रेज़ी में ही उन्होंने अपना MA किया था। उर्दू से लेके संस्कृत, राजनीति से लेके फिलॉसफी, विज्ञान से लेके कला, साहित्य, संस्कृति और फिर खाना। भोजन भट्ट थे नीलाभ जी, और भोजन के बारे में बहुत बारीक नज़र रखते थे, लिखते भी बहुत खूब थे। मेरा उनके साथ साथ आउटलुक के समय से रहा। बेमिसाल व्यक्ति, बेहद मददगार, मिलनसार, दिल अजीज़ दोस्त, मेंटर, इतने ज्ञानी लेकिन मानो अहंकार कहीं से छू ना गया हो, हर व्यक्ति के लिए मदद करने को तैयार, एक ऐसा संपादक जो शायद इस समय विलुप्त प्रजाति है। इस तरह के संपादक, और ख़ास तौर से हिंदी में इस तरह के संपादक मिलने मुश्किल हैं। उनके दोस्तों और चाहने वालों का दायरा इतना बड़ा है कि हैरानी होती है कि एक ऐसा शख्स जो ज़िंदगी भर लो प्रोफाइल रहा, वो इतनी बड़ी छाप कहाँ कहाँ छोड़ गया। वे हमसे बिछड़े 24 फरवरी 2018 को, और इसके बाद से लगातार साल में 2 बार हम उन्हें पूरी शिद्दत से आपकी मदद से याद करते हैं। 24 फरवरी को यानी उनकी डेथ एनिवर्सरी, और एक आज का दिन 16 जून यानी उनका जन्मदिन। इस मशाल को जलाए रखने का काम आप सबकी मदद से कविता श्रीवास्तव, नीलाभ जी के दोस्त और उनके परिजन कर रहे हैं। हम आज के मेमोरियल लेक्चर को सुनने से पहले एक नज़र इससे पहले हुए मेमोरियल लेक्चर पर डालेंगे। पहला मेमोरियल लेक्चर 2018 में वरिष्ठ पत्रकार व नीलाभ के घनिष्ठ मित्र पी साईनाथ ने दिया, फ्रीडम ऑफ द पर्स, हाउ कॉर्पोरेटाइजेशन ऑफ मीडिया हार्म्स द इंडियन डेमोक्रेसी, chaired by academician Dr. Nivedita Menon. In 2019, second was delivered by renowned musician and writer T.M. Krishna on From the Notes of the Word, chaired by Sahityakar Ashok Vajpayee. 2020, the third memorial lecture was given by writer and human rights activist Harsh Mandar on how we can live together, imagining a new social contract, chaired by journalist Pamela Philippos. In 2021, fourth was delivered by senior advocate and former UN Special Rapporteur on right to health, Mr. Anand Grover, on rule of law in the times of COVID-19, chaired by Dr. Vandana Prasad. 2022, the fifth was delivered by renowned filmmaker Saeed Akhtar Mirza on manufacturing hate, chaired by eminent social activist Aruna Rai. And today, as we all know, we all are here to listen to the sixth memorial lecture, which is being delivered by well-known, loving, charming, ever-young Indra Jaisingh. She is senior advocate in Supreme Court, fearless lady who has shown the way to many of us how to fight within the system and outside and smash inequality and patriarchy and all form of injustice. Need not to mention, as we all know, she was first female additional Solicitor General of India in 2018. She was ranked 20th on the list of 50 greatest leaders of the world by Fortune magazine. Founder, Lawyers Collective, Leaflet, and now when we watch live telecast of Supreme Court proceedings, we definitely owe you a big thank because your letter showed the way. Human rights and gender equality आपके दिल के और काम के बहुत करीब है और इस दुनिया में एक बेमिसाल काम आपने किया। आज आपसे हम जिस सुलगते हुए मुद्दे पर बात सुनेंगे, दरअसल वह देश व लोकतंत्र के डगमगाते भविष्य से जुड़ा हुआ है। Today she is going to enlighten us on a very crucial and critical issue, जिसे लेकर हम सब परेशान हैं, दिल पर बोझ है और कई बार लगता है कि ऐ वतन तुझे हुआ क्या है, ये अच्छा है तो फिर बुरा क्या है। She is delivering lecture on From Ignoring the Constitution to Repudiating It, Failing Democracy. संविधान की उपेक्षा से लेकर संविधान को सीधे सीधे नकार देने तक विफल लोकतंत्र। इस सेशन को चेयर कर रहे हैं मैं आग्रह करूंगी वरिष्ठ अर्थशास्त्री पराकाला प्रभाकर जी से कि आप प्लीज़ मंच पर आएं, जो बेहद तीखे राजनीतिक अर्थशास्त्री हैं और उनकी किताब जो इस समय आपको बाहर भी दिख जाएगी, यह किताब इस समय सत्ता के गलियारों में बड़े सवाल के साथ घूम रही है। द क्रिकेट टिम्बर ऑफ न्यू इंडिया, एसेज ऑन अ रिपब्लिक इन क्राइसिस। इस किताब ने जिस तरह से नए मौजूदा हुक्मरान को परेशान सवालों के साथ घेरा है, विनाशकारी नीतियों को तथ्यों के साथ समेटा है, वो निश्चित तौर पर इस पूरे के पूरे निज़ाम पर एक बहुत बड़ा सवाल है। उन्हें कम्युनिकेशन स्ट्रैटेजिस्ट के तौर पर ख्याति प्राप्त है। वे पूर्व में आंध्र सरकार के सलाहकार भी रह चुके हैं। मैं अब आग्रह करूंगी इंदिरा जयसिंह से कि आप मंच पर आएं।
I would like to say a few words about my relationship with Neelabh. As time goes on, you will see I'm going to begin this speech with a quotation from Mahatma Gandhi. But the inspiration for that came from Neelabh himself. He sat me down one day and he explained to me how his grandfather, at the age of 15 years, met Mahatma Gandhi in West Champaran, and that changed his life forever. He left college and dedicated his life to active politics. Now, again, when it comes to Neelabh's father, really both of them are the inspiration for me as much as Neelabh. So he personally told me this whole story. And about his father also, he was a very active politician. He was an MLA and followed in the footsteps of what he had learned from his father about Mahatma Gandhi's involvement with the freedom movement. And then, of course, Neelabh. And I have not spent too much time with Neelabh, but whenever I was in a crisis intellectually, I would pick up the phone and talk to him and say, please, can you come and discuss this issue with me? I do love discussing problems to which I don't find answers with people I trust, and he was one of them. So I did that. And I was just sharing with Kavita this morning that every time he came over to my house, I would ask him, what would you like to eat, Neelabh? By that time, he was already ill. He already had a genetic problem relating to his liver. And every time he would say khichdi, and my maid Lakshmi would cook khichdi for him with ghee. She would go out of her way to cook for him. So I have a very emotional link with Neelabh, not so much in terms of time, but in terms of a spiritual and a mental connect. And so I'm really delighted to be here. Neelabh, this is for you. Okay. I think the title of my lecture actually says it all. If I'd stopped there and said nothing more, I think the entire concept that I want to convey is conveyed in this one sentence: ignoring the Constitution, from ignoring the Constitution to repudiating it. I'm going to take you through a few stages in the development of this idea that I've been working on for the last 3 or 4 years. So let me begin by saying, yes, the title of this article says it all, this lecture says it all. This is my understanding of the present regime, that they have, they have been ignoring the Constitution since 2014, but today I was shaken up by the events which happened on the 28th of May, 2023, and that's when I coined this expression, repudiating the Constitution. So I think that's like the ultimate stage of this journey, which they began in 2014, and it's going on, but on the 28th of May, I think there was a qualitative change. It was not just a media event. It was a repudiation of the Constitution, and that's why I have titled this little lecture, Repudiating. Now, what has bothered me is we need to understand the process through which we reach this milestone. And that is what I'm trying to convey to you in this lecture. What is my understanding of the process through which we have reached here? But before that, I'd like to say, what is it that qualifies me as a lawyer to deliver this lecture? There are many others in this audience who are far, far more qualified to deliver this lecture. Many others who've worked their way through the politics and the economics of this country. But I was again inspired by a quote from Mahatma Gandhi. When he was being tried for sedition, he was told by the British, those who live by the law must keep the law. And this was his retort: if it means that lawyers may never commit a civil breach without incurring the displeasure of the court, it means utter stagnation. Lawyers are persons most able to appreciate the dangers of bad legislation, and it must be with them a sacred duty by committing a civil breach to prevent a criminal breach. Lawyers should be guardians of law and liberty, and as such are interested in keeping the statute book of the country, quote, pure and undefiled. Now, it saddens me. I had shared this quote with a friend of mine and asked her what she thought about it. She shared it with her son, who's a lawyer. He came back to her and told her, this is not true, he said. And the example he gave is that when Kanhaiya Kumar was produced in the court, it was a bunch of lawyers who did exactly the opposite of this. They attacked him. inside the premises of the courtroom. So she turned around and said, her son turned around and said to me, how can you say this? But I decided to stick to my trajectory, which is that it is the sacred duty of lawyers to keep the Constitution of India, quote unquote, pure and undefiled. So in conditions that obtain in the country today, there are apprehensions which are very well founded that the Constitution may become a mere artifact to be kept in a museum. So apart from keeping it pure and undefiled, we also have to critique the entire process through which we got here. So how did we get to this stage? So the preamble to the Constitution was meant to secure. The word secure is very important. It is in the preamble to secure to its citizens justice, liberty, equality, fraternity, and dignity. And what I find is that the methodology by which the ruling party has brought us to this pass is by replacing these words. Now, how have they replaced these words? The justice has been replaced with injustice. Liberty has been replaced with repression. Equality has been replaced with discrimination. And fraternity has been replaced with hatred. And dignity with demonization. So this is the method, it's the core values of the Constitution which have been simply replaced without amending the Constitution. This is the big mystery about what's going on in this country today. How did they manage to do it without amending the Constitution? Now, it's a journey which has been a long journey, 75 years. I don't know what they call it. I think they call it Amrit Kaal, whatever. But it has been a journey. And there is a particular quote from a judgment by Justice Chandrachud in the Februrary case, where this is how he describes the journey. This is a quote. Reading Dr. Ambedkar compels us to think about the other side of independence. Besides the struggle for independence from British rule, there was another struggle going on since centuries, which still continues till today. That struggle has been the struggle for social emancipation. It has been the struggle for the replacement of an unequal social order. It has been a fight for undoing historical injustice and for righting fundamental wrongs with fundamental rights. The Constitution of India is the end product of these two struggles. So, I consider this to be a very beautiful passage in which he has described the journey through which the Constitution was not only enacted, but through which it has to be kept pure and undefiled. So, my own work has been, and the work of civil society has been on this, what he calls the other side of independence. All democratic and non-violent struggles have been located on the other side of independence in these 75 years. It is also what has inspired my work as a lawyer. To use a cliched phrase, as one of Midnight's children, I'm ancient. My earliest memories go back to India's first Independence Day. As a child, my father had taken me to watch what he called the lights of independence. Until this day, when I pass the Municipal Corporation of Bombay and what was once called Victoria Terminal, you will see those two buildings lit up in exactly the same way as they were on the very first day of independence. But of course, a lot has changed since then. As a migrant to this country, as a refugee from Pakistan, I saw only one picture adorning the walls of my newfound home, and that was the picture of Mahatma Gandhi and Nehru leaning in and talking to each other. And I kept wondering, what is it that they're talking about? So what was it that attracted people like me and my family to this country? It was not our ancestral home. This was not our village. It was our hopes and aspirations of a less beleaguered future that brought us to this nation. It was a feeling of finally having found stability within which day-to-day life could go on. It was the fraternity and pluralism of the Constitution which was a safe haven for all of us. That space of stability, that safe harbor, was a space within which we could find the values of equality, non-discrimination, freedom, liberty, and dignity. It was the Constitution, which was our link to citizenship and nationhood. My own work was guided by the directive principles of state policy, fundamental to the governance of the country, in which I found my own bearings as a lawyer. Being the outcome of a political struggle, the Constitution embodied political principles, but, and this is what I want to emphasize, it also created a legal order, which was made expressly enforceable by the judiciary. So, mind you, the Constitution is not just a political document. It is also the supreme legal document which enables us to enforce the rights which are granted in the Constitution. These rights, of course, were given by the Constitution, but the struggle has been to implement these rights. Now, I'll just say a few words about the division of rights in the Constitution. They're divided into what we call social and economic rights, which are progressively realizable, and civil and political rights, which are immediately enforceable. Now, the immediately enforceable rights are the right to freedom of speech and expression. They don't need a progressive realization. Whereas the economic and social rights, such as the right to work, the right to housing, they are progressively realizable because they were linked to the stage of economic development in the country. And I believe this distinction came about internationally. People have rejected this distinction, but the distinction does exist in the Indian Constitution as well. Now, I think that people of my generation, we took our civil and political rights for granted. We thought they would never end. We thought they would never be taken away from us. We thought this was a constitution without end. And we saw our challenges as working towards implementing social and economic rights, which is the reason why most of my early work focused on the right to housing, the Olga Tellis case, the Bombay Hawkers Union case, several cases we raised the issue of the right to work, the right to housing, the right to minimum wages, etc. And progressively, these rights were implemented by the courts. Today, of course, I stand at a different juncture because, like many of you in this audience, I too have my political and civil rights have also been taken away and targeted. Targeted with an FIR, which we'll talk about a little later. So today we find ourselves not only in a situation in which our civil and political rights are taken away, but also our social and economic rights. We not only see a de facto erasure of secularism from the living practices of the state, but also a failing democracy, which is brought about by the collapse of the separation of powers between the legislature, executive, and judiciary, but the breaking down of constitutional barriers between them, independence of other institutions such as the CBI, ED, CVC, described by Justice Kabadia as institutions of integrity. They have been robbed of their independence and of their integrity. This is, of course, evident from the fact that 12 political parties filed a petition in the Supreme Court unsuccessfully, saying that the ED is targeting them. More recently, Justice Joseph called them guarantor of fourth branch institutions, such as the Election Commission, which needs to be insulated from powers of majorities and to deliver their mandate independent of ruling parties. Now, political parties do not honor rulings of the Supreme Court. And one of the cases which I had discussed with Neelabh also was what is known as the Abhiram case. The Abhiram case interpreted Section 123 of the Representation of People's Act. And the issue there was, can anybody campaign for an election based on religion? And the Supreme Court said no. Canvassing for votes on the basis of religion by you or your agent or anybody to whom you have given a consent is illegal. And yet, of course, we all saw the spectacle of a high-ranking minister of this country saying one day before the election that when you press the button, please say Jai Bajrangbali and cast your vote. Now, all this is going on without any form of accountability. I already told you that the Constitution is a document which is meant to hold people to account. So, what has happened is that the Constitution has been denuded of its enforceability. and it has been reduced to a document of pure and simple political intent to be enforced by an executive at its discretion. There is no legal accountability anymore. All this has been achieved without amending the Constitution. And this is the question that has been bothering me. How can you do all this without amending the Constitution? So we try to look for reasons. And looking at these reasons, I tried to look back 75 years. So the question that we do need to ask ourselves, how has it come about? Now, law is nothing but the written word. We are governed by the written word. And this written word obviously can only be altered by amendment through written words. What we are seeing today is that the text of the Constitution remains in place while its core values of justice, equality, liberty, fraternity have been repudiated. Now, of course, Keshananda Bharati was decided in 1973, and it held that the basic features of the Constitution, such as fundamental rights, secularism, democracy, federalism, could not be amended, even by a constitutional amendment. While the Constitution of India has been often amended, its basic features have been maintained in judicial discourse. The judges will tell you all the time, democracy is a basic feature. They will say federalism is a basic feature. They will say that these cannot be amended by a constitution. So what do you do? What does the government do? They find a way of amending without amending. Yet today, we see the same result as we would have seen if there was an actual amendment of the Constitution. How have they done this? In my opinion, it has been done by creating a norm higher than the constitutional norm. Now, we have all been brought up to believe that the Constitution is a good norm. But what we are seeing today is that discourse of the ruling party is to say there is a norm which is above the Grun norm. And that norm we'll come to that in a minute. Obviously, that norm is Hindutva, which is over and above the norm that the Constitution puts in place. And so the entire Constitution has to be interpreted with reference to that norm. They found a way, they found a device by which they have gone around the Constitution and gone around the need to amend the Constitution. But of course, after 2024, one doesn't know if they come back to power. We'll see the amendment. But as of today, as I speak today, there is no amendment, and that is why I am entitled to stick to the letter of the Constitution and say this is my Constitution. So you have the creation of a norm which is placed above the norm of the Constitution. A new set of practices have replaced constitutionalism and legality and have been elevated to a level above the Constitution, with reference to which the Constitution and its basic features have to be interpreted. See, every written document requires interpretation. Every document. It has to meet the challenges of time. It has to cater to the needs of the younger generation, the future generation. And that is the process of interpretation. So every constitution has to be interpreted by judges. Now, so how is this interpretation being done? It's being done with interpretation to a norm which is outside the Constitution. Rights have been, as we know them, have been replaced by duties, negating the entire chapter on fundamental rights. I had occasion to deal with one of the beef ban cases in the Supreme Court of India, which arose from an appeal from the High Court. And I was shocked when I read the judgment authored by Justice Lahoti when he was Chief Justice. See, you must understand the process through which this happens. So there were those cases which said that you can slaughter animals. Even cows can be slaughtered after the age of 16 years when they cease to be productive. All that changed with Justice Lahoti's judgment. But, you know, one thing you must grant to the ruling party, they have a lot of patience. He waited. He waited and waited and waited till he became the Chief Justice. And then he packed the court. He constituted a court of 7 judges. And he wrote a judgment overruling all the previous judgments. And in that judgment, when I was reading it, I was trying to look at the methodology. How has it been done? And I found that he referred to fundamental duties. And he said, these are the duties that I'm implementing now. And that's when I realized what's happening in the courts is a reversal between the two chapters of fundamental rights and fundamental duties. And fundamental duties are now being used to deliver judgments, forgetting that there is a chapter on fundamental rights. That's when it hit me to begin with. So there is a new language which we hear all the time, which is our intrinsic dharma of the people of India, which is ancient and which predates the constitution. This is the point. If this predates the constitution, then you can use it to interpret the constitution. That's the argument that we are given. Once a norm about the constitution is created, it's easy to see why there is no need for an amendment, because there is a norm which is more basic than the basic features. Save for two significant amendments, which we all know about. One was the abrogation of Article 370 of the Constitution of India, which was very interesting. It was done during a period of President's rule, and it was done simply by changing the language from the consent of the state government to the consent of the president. And during that period, it was president's rule, and so virtually the central government gave consent to itself. That's how they achieved an abrogation of Article 370 of the Constitution of India. So you see, words can mean what you want them to mean. And you just redefine what state assembly means, and you've achieved a constitutional end. And of course, the other one was the amendment to the introducing reservations for economically weaker sections, which specifically says that it excludes scheduled castes, scheduled tribes, and OBCs, meaning thereby an amendment which gave reservation to the upper caste. But that at least had the benefit, had the credibility of being introduced through an amendment to the Constitution. No doubt the amendment was never debated in Parliament. The amendment was passed within a matter of 5 minutes, and every political party agreed to that amendment. I won't take you through the long journey where it was argued in court and the court upheld it. Now we come to, in the journey, I come to the emergency of 1975. I see people here in the audience who were also around when the emergency was declared and who were actually arrested. I wasn't arrested, but my office was certainly raided because we were providing legal services to George Fernandez and the railway workers who were dismissed. So that's when we got the real rude shock, where we realized that our civil and political rights, which we thought would never be taken away for us, were actually taken away. The legitimacy of protest, which was a legacy of the independence movement, the legacy of non-violent struggle and civil disobedience, was brought to a brutal and abrupt end when the emergency was declared in 1975. The emergency was declared, there's a point I wish to make here, which is rather important. The emergency was declared based on Article 352 of the Constitution of India. So there was an internal exceptionalism in the Constitution which was used to declare the emergency. There was no repudiation of the Constitution. There was no ignoring of the Constitution. It was a constitutional device that was used to declare an emergency, however wrongly, however much the result, the outcome would have been a complete suspension of our civil and political rights. But the legitimacy of the Constitution was not denied. It was declared by an elected executive. Now, of course, we know there was no cause for it. And look at the way, I've been looking at what happened to people who were opposing the emergency, and I found that the law of sedition was not used against them. They were preventively detained. Whether it was Jayaprakash Narayan or whether it was anybody else, there was a preventive detention law under which they were detained. But Section 124A of the Indian Penal Code was not used against them. Today, you see it being used, as I will say, for every petty occasion. We use it. Of course, the habeas corpus petitions were rejected. We all know that. ATM Jabalpur, I don't have to labor the point. Of course, the emergency did meet with massive protests, which ultimately led to the withdrawal of the emergency and the declaration of elections, at which the party which declared the emergency was thrown out of power. When the new government came to power, the constitution was again amended to remove the ability to declare an emergency on internal disturbance. Again, through a constitution. So you see, throughout this period, it is the constitution which is the center of our discourse. It meant that throughout the emergency, the Indian political discourse centered around the Constitution of India. It was the universe around which all of us argued our cases. The emergency demonstrated the strength and the malleability of constitutionalism. It demonstrated that political processes and parties and individuals approach a written document, namely to shape and approach their attitudes. This was it. But during the emergency, both those who supported it and those who opposed it appealed to liberal democracy. Both Mrs. Gandhi and Jayaprakash Narayan called each other fascists. And both of them said, what we are doing is we are restoring liberal democracy. So that I have taken from a quote from Bipin Chandra, who in his book In the Name of Democracy says, the defense of Indian democracy seems to have been the main justification for both the JP movement and the emergency. So the point I'm making is you still have some respect for the constitution, even if you declare an emergency. When we come to the present phase, it's not what we are seeing today at all. The ruling party, as I said, does not appeal to the constitution. It appeals to a norm above the constitution, by which we are supposed to judge the legality of state actions. In other words, there is something more basic than the constitution itself, more basic than the basic structure of the constitution, by which accountability is to be judged. And if they comply with that, then they are clean, home and dry. We are not entitled to criticize them. So it's a clever device by which the constitution itself has been ignored. It's been bypassed. And they don't have to feel any sense of guilt for it. And as I said, all they've done is replace the values. They've replaced the values of justice, liberty, equality, fraternity and dignity with hatred, discrimination, as I said earlier. But it was those values which gave us a sense of identity, self-worth, and empowerment. So what we are seeing today is a suspension of these core values, in effect, a suspension of the constitution itself. At least Pakistan had the courage to, in writing, suspend its constitution. What we are seeing in India today is a suspension of the constitution, but without a written document. To call it an undeclared emergency does not capture the process through which this has come about. There are major differences between the two. While the emergency did not deny the legitimacy of liberal democracy, as such today there is no pretense by the ruling party to defend liberal democracy. Efforts are made to transform the state, not one governed by the constitution, but by the ideology of cultural nationalism. So that is the norm that I was talking about, the norm above the norm. There is now a Hindutva jurisprudence which has entered the courtroom, which holds that culture is a norm above the constitution, with reference to which the constitution must be interpreted, not by its written word. The constitution, including its preamble. Now, it is my belief that the constitution, including preamble, is a sui generis document. It cannot be interpreted with reference to anything that went before it. There's no question, because it represents a revolutionary break with the past. With the march of time, all written texts, of course, do require interpretation, and so does the Constitution. But because it's a sui generis document, it can only be interpreted with reference to itself, internally. As I said, it represented a complete break from everything that went before it, and hence the ideology of past political religious ideologies cannot be used to interpret the Constitution. Sadly, what we are seeing today is an appeal to the Vedic past and their text to interpret the Constitution, forgetting that it was an unequal, obscurantist past, which was being discarded in favor of democracy and empowering rights and freedoms. The cultural past to which the appeal is made is, of course, one culture. We all know that. I don't need to repeat all this. It governs our duties, to the nation, and our adherence to this culture will determine whether we are patriotic or anti-national. Human rights, as we have known them, we are told, is a Western import. The caste system, we are told, never existed. Scientific temperament was completely abandoned in favor of superstition and obscurantism. Now, this, I think, in one of the lectures with Mr. Grover delivered at the Neelabh Memorial Lecture, very elaborately, he had explained how, when it came to COVID, the decision making was taken out of the hands of scientists and vested in, guess who? One person, the Home Minister. And how was this achieved? It was achieved by invoking the Disaster Management Act, which is directly executed by the Home Minister. That was the legal device. Unlike many other countries which enacted legislation to deal with the pandemic, India did not enact any legislation to deal with the pandemic. Now, it pains me to talk about the judiciary, but I guess I have to. When the NJAC decision was rendered, we were told that the judiciary will retain its primacy in the matter of appointment of judges. And it was the late Arun Jaitley who made that immortal statement that the will of the majority has been defeated by an unelected judiciary. And yet, they continue to be in power, and they did not introduce a new law. They did not introduce a new amendment to the Constitution, bringing in a more democratic collegium system. All we saw is dog whistles from the Law Minister, Rejuju, and the Vice President of India in an attempt to chip away at the credibility of the judiciary. But let's look a little more closely at the judiciary. We are told that the collegium system was intended to keep the primacy of the judiciary in the matter of appointment of judges. Now, this is it. This is where you can pollute the fountain at its source in the matter of appointment of judges. So, and that power is kept within the hands of the judiciary till today. They do have the primacy, and they do make appointments through the collegium. While this was what we were told, the recent history of the Supreme Court tells a different story, a very comfortable coexistence with the executive through a system of give and take. Now, the prime example of this is, of course, collegium recommendations not being implemented. In particular, Justice Akhil Qureshi, who was involved in the Sohrabuddin case when he was in Gujarat, he would never ever make it to any high court of a state which was ruled by the BJP. Yeah, sometimes they post you in Congress-ruled state and say, go there and make your trouble. The most recent example, of course, was the case of the appointment of Victoria Gowrie, whose videos are available till today on YouTube, where she talks about Christians as being involved in white terror, which is worse than green terror. And yet, this woman was recommended for appointment to the Supreme Court of India by the collegium headed by the current Chief Justice of India. A more dramatic example of hate speech cannot be found. And it confounds me how the Supreme Court can deliver judgments on hate speech on the judicial side, and on the administrative side sanction the appointment of people. When challenged, of course, the petition was rejected. So, when it comes to the judiciary, the issue is, why bother to amend the Constitution if you can do it through the back door, what you can't do through the front door? Take the talk of diversity in the judiciary. Very recently, there was a lot of talk about diversity, and yet I don't know whether you know this, that 40% of all sitting judges today in the Supreme Court are Brahmins. I can't see the diversity that is being talked about, and these distortions in proportionate representation is what encourages majoritarian approaches to lawmaking and to decision making. Their judges are also very talkative off the bench, and many of them love to accept invitations from the Adhivakta Parishad to come and deliver lectures, almost every one of them. And at these lectures, you really get an insight into their mind. And they have been saying things like, oh, you know, Article 72 of the Constitution and Section 332 of the Constitution existed in India and is mentioned in Valmiki's Ramayana. And then you have another judge who, mind you, a Supreme Court judge, who said, quote, it is accepted that India had a justice system even during the Bronze Age. And Kautilya's Arthashastra, he said, knew about legal realism long before foreign scholars even coined that word. This attempt to link the jurisprudence of the constitutional India to Kautilya is a direct assault on the ethos of the constitution, and it runs across the executive, legislature, and judiciary. The attempt here is not to de-Brahmanize, but to reinforce the references to Arthashastra selectively and politically. As Brijnarayan Mani writes in De-Brahmanizing History, and I quote, in the Arthashastra, the much acclaimed treatise, and this is a Supreme Court judge, mind you, saying this is what India's legal system is all about. In the Arthashastra, the much acclaimed treatise on statecraft, Kautilya is concerned with the preservation of Varna Dharma through Danda. In the same way, Danda alone protects this world and the next. His Danda is employed to uphold the Vedas. Kautilya, the alleged architect of Hindu secular statecraft, requires every Varna to perform its functions. The world will be destroyed, he tells us, if we do not honor our Varna Dharma. He instructs the king that he should never allow the people to deviate from the path of caste duty. And we have judges of the Supreme Court quoting him as their inspiration. These values of the constitutions were gifts of the freedom movement and the anti-colonial struggle, which was cemented into the constitution by Dr. Ambedkar. There was a conscious attempt to de-Brahmanize society and to deny the caste system through Article 17 of the Constitution of India. So I don't understand how judges can talk like this, but they do. Now, quickly, when it comes to each branch, when it comes to executive, I suppose the Janata Party did have a policy that you cannot be a member of two organizations. You cannot be a member of the RSS and be in the government. This regime has no such policy. And that is why you will see, in fact, the ban on the RSS, I'm told, was removed because it claimed to be, quote unquote, a cultural organization and not a political one. And yet today, you will see in the government, the statistics are well known, how many ministers have their origins in the RSS. So that's on account of the fact that there is no ban on being a member of two organizations. So you can see the agenda being implemented on a day-to-day basis. There are many examples of it, whether it comes to the curriculum or whether it comes to the Akhand Bharat map, which is installed in Parliament, leading to protests from neighboring countries, or it is the changing the names of cities. I was once approached to do this case about name change of Aurangabad, and the people who were bringing the case to court told me, we don't really mind a name change. What we do mind is that they have named it Shambhajinagar. And the reason is that it will lead to a feeling of revenge. And even if you want to change the name of a city, why are you encouraging revenge? And now you can see all the riots that are happening in Kolhapur. Decision making must be based on data. As I said, in COVID, it was not based on data. Scientists were ignored. The attempt was to centralize power in the hands of one single person under the Disaster Management Act. Politically neutral bureaucracy has also been turned into a political institution. And in my opinion, the function of the bureaucracy, the IAS, has been outsourced to the Niti Aayog. Talking to a few senior IAS officers, they told me we have been reduced to doing the function of registrars to our ministry, where all we have to do is put a stamp on the decisions taken at the Niti Aayog. Parliament obviously has been undermined by and being refused to function. But one particular amendment which affects all of us and certainly affects me deeply, because me and my partner have both received notices under the Prevention of Money Laundering Act from the ET summoning us to come and attend their office. The issue here is that these amendments were passed as money bills under Article 110 of the Constitution of India, bypassing any debate. I'm not aware of how a crime can be created under a money bill. The crime was actually created under a money bill. Now these challenges are pending in court, but how long I don't know whether they'll be decided in my lifetime. But never mind, they have to be decided sometime. So the media, we all know the way in which it has been defanged. Digital media, and Bhasha mentioned that me and my partner, we were founders of the Leaflet, which is a digital legal portal. And when these rules were introduced, we thought that it was our duty to challenge the rules relating to digital media. And we did challenge it in the Bombay High Court, and I would say successfully, where the High Court stayed the operation of a rule which enabled the government to direct us to pull down any data. And this is what the court said, quote, people would be starved of liberty of thought and feel suffocated to exercise their right of freedom of speech and expression if they are made to live in the present times on content regulation on the internet with the code of ethics hanging over their head as a sword of Damocles. This regime must run clearly contrary to the well-recognized constitutional ethos and principles, quote unquote. But despite judgments of this kind, their subsequent amendments have come. As you know, they're putting in place a fact-checking unit, which will be that belonging to the government of India. Coming to civil society, as I said, many of us in this audience have faced the ED. And why is it surprising? It's not. Because it was Ajit Doval who said publicly that now the war will be fought through civil society. We know all this about how FCRA licenses have been cancelled, how notices have been sent. Of course, it's very painful to open the morning newspapers and to read that Teesta Settlewat is being told that she had manipulated the legal system, cooked up a controversy, cooked up a conspiracy. Mind you, it is the judiciary which is single-handedly responsible for victimizing her. Let's not have any illusions about that. And then we see that rapists have been acquitted, and we've also seen how in the Best Bakery case there's been an acquittal on the ground that the individual role has not been proved in court. So what was that entire battle from 2002 to today all about? I really don't know. So how does this happen? See, in a court of law, you're told that a misuse of the law is no reason to end the law. It's no reason to abolish the law. It's no reason to declare it unconstitutional. But in my opinion, abuse of law is no longer abuse of law. It's policy. It has been elevated to the level of a policy. In my opinion, the ruling party uses the law knowing that it is illegal. And I have to say that this came as a surprise to me some time ago when I was dealing with the case of a police officer in Gujarat who was told that he must take action against Malika Sarabhai. And he said, look, he told the then chief minister, I've done an investigation and I've found that there is no evidence against her, so I have to close the case. And he was told by the then chief minister, I don't care whether there's evidence against her, no evidence against her, you have to file the FIR and let's fight it out in court. So if this is the policy in which criminal law is being used, then it's squarely unconstitutional. Prosecutorial decisions are outsourced to the party. Obviously, a new language has been invented. We all know this, that this is how the language is being used against us. And I would just, on the other hand, we know that there is impunity for the right-wingers who can say what they want to say and get away with it. It is as if they have been given amnesty in advance. It is as if they have been given a pardon in advance of going through the entire drill of prosecution. It's no different from that. So these are the twin ways in which impunity operates, impunity for them, and a policy decision as far as civil society is concerned. So it is that this is the reason why I use this title, this is the reason why I started this lecture by saying that the Constitution has been ignored, and it has been now repudiated. So I would like to definitely now say a few words and end there about the final stages of this 75-year journey, which I believe occurred on the 28th of May 2023, when the new parliament was inaugurated. And as a lawyer, if I look at it, it is a repudiation of the constitution altogether. It is not my case that a new parliament should not have been built. You can't build a new parliament building if you feel that the old building is not large enough to accommodate what you are anticipating after the delimitation of 2026. The other governments also attempted to build a new parliament. They didn't get around to building it. So that's not the issue. The issue is that parliament is. It's also not the issue why wasn't the president invited. Of course, she should have been invited, but that's another issue. But the real issue, of course, is who does parliament belong to? Parliament is a creature of the constitution, and it's the house of people. It's called the house of people. So the question is, how is it that in the house of people you can install a symbol, which is a symbol of kingship, which is a repudiation of everything that republicanism ever stood for? It is a rejection of the liberal core of the Constitution, which found its reflection, as I said, in the preamble. It is the spirit, it's the Republican spirit in its purest form, which saw sovereignty vest in the people, which is the heart of the Constitution, and which is the legitimate source of power for the ruling party. The installation of the Sangal by the Speaker's chair. I mean, I don't know if anyone has an answer to the question why it was installed at the Speaker's chair. I don't know. Someone was having a discussion with me and said, well, in any case, it's a symbol of the executive, so why shouldn't it be in the Prime Minister's chamber? Why is it in the Speaker, by the Speaker's chair? There's no answer to that, why it is there. And of course, what we are told is that it's there to remind us of our dharma. But those of you, I don't know if any of you have entered the new parliament, but I'm told that above the canopy of the Speaker's chair, there is already a Buddhist sutra which talks about Dharma Chakra, and that this Dharma Chakra must go on. So why we needed one more symbol is anybody's guess. Now, so therefore, why do I say it can never symbolize the transfer of power? Parliament has been established by the Constitution of India. The Constituent Assembly, which enacted the Constitution on the 25th of November 49, did not derive its authority to frame the Constitution from any Songal or any Brahmanical edict. The Constitution Assembly received its sovereign power from the British Parliament under the Indian Independence Act of 1947. That's what my legal training tells me, in respect of British India territory. With regard to the princely states, like Mysore, Baroda, the Constituent Assembly got its power by transfer under instruments of accession signed by the princes after the lapse of British paramountcy. Neither the British Parliament nor the 500 princes acquired their sovereignty of power by divine origin. So therefore, it will remain a mystery. Not just a mystery, but also a turning point. I don't think it was just another event which we can say, oh, he's given to event management. The Constituent Assembly enacted the Constitution, bringing in the words "we the people." After the Constitution came into force, transfer of power. Now, that was the origin. But after the Constitution comes into force, transfer of power takes place at an election. Regime change happens at an election. Through elected sovereign power vests in the people, delegated to their representatives in Parliament. The stated justification, as I told you, was that we need to be reminded of our dharma. So, in my opinion, 28th May 23 marked the beginning of yet another transformation of the Indian state. From ignoring the Constitution, we have reached a stage where we have repudiated its very origins. The installation of the Songal next to the Speaker's chair represents this repudiation of republicanism. It's a truism which no one can deny, that sovereign power rests with the people. So, as I said, we have no problem with building a new parliament, but I have a problem with the installation. Then, of course, the presence of priests at the ceremony cannot but be seen as contrary to secularism. We have Article 28 and 29 in the Constitution which say that state funds cannot be used for education. If they can't be used for education, how can they be used for anything else? The state has no religion to follow or promote or to propagate. What is heartbreaking is to see judges attending the inauguration. Why they did it, I don't know. So this is the contrast that I have been trying to make, and I'm going to conclude here. While during the emergency of 1975, fundamental rights were suspended, what we are witnessing today is a suspension of the very constitution itself. Now, at least in Pakistan, there was the merit of a written document which suspended the constitution. We don't have any such document here which we can challenge or hold our ruling party accountable in a court of law. Through these combinations of strategies, which include divide and rule, they have succeeded in doing what I say they are doing, that is repudiating. So there is a big difference between, sometimes I hear this is an undeclared emergency, and that's why I wanted to take this trouble to say, no, this is something very different. We know that Mrs. Gandhi used constitutional means to subvert democracy. She did not ignore the Constitution. What we are seeing today is, and she used the exceptionalism in the Constitution itself. The present government is simply ignoring the Constitution and now repudiating it. When abuse of power becomes a policy, it begins to look like the new normal, and few of us bother to challenge it. I'd like to just end by saying that constitutional remedies are often ex post facto. So I would like to wait and see where this installation is going to go. And I will conclude by saying that, in one of my earlier lectures, I had said, that the illusion of democracy is really more dangerous than the absence of it. Today, I would say that the illusion of a constitution is more dangerous than the absence of it. Thank you.
Yeah, in your speech, you mentioned integrity and dog whistle, the two very important aspects of the present time, integrity. So if it is a top-down integrity, when it comes, you mentioned about some institution on the integrity part, and dog whistle in your speech. So question is, integrity is not isn't it top-down that every institution would have? Well, you mentioned.
I remember it very distinctly. And the critique of the government at that time was that why did you delay the entry of the army by 2 days? So my answer to my way, the constitutional way, and there is a mystery around what are the legal situation in Manipur, because I recollect seeing a few news reports that Article 355 had been invoked. And in spite of that, I looked everywhere to find any document invoking Article 355, I couldn't find it. So the legal situation in in Manipur is very ambivalent as of now because of the absence of that document. But my way of looking at it was that when we made this demand in Gujarat, that why did you delay sending the army by 2 single days to Gujarat, enabling a genocide to take place? It's the same thing being replicated in Manipur, and in my opinion, President's rule should have been declared long back. To bring, the only core function of any central government is to maintain law and order and security so that people can go about their life in a day-to-day manner. They have failed in that core function.
The regime is doing right now, isn't this what democracy is? And second one is, you talked about the repudiation of the constitution. Do we really have to limit ourselves within the constitution? Doesn't it hinder the free thinking of the political right of a human being, of a free thinking being?
My question is related to the right to protest. The reason why I'm saying is that I'm a student activist, and my fellow student activists are on a day-to-day basis are being slapped with Section 144, not on anywhere else, but in the same universities. Delhi University, my fellow comrades, I think have 70 to 80 FIRs. I think Apurvan sir also knows this. The question comes in this perspective that why is judiciary on a day-to-day basis looking at a very narrow view of right to protest? one, it is segregating at a very different place, and every other space is being seen as something that it's a no-go zone. On the contrary, for the hate campaign and for the hate speeches, the whole country is a space. And I mean, it just wonders for us to see what kind of thinking is happening there within the judiciary, that this is bad and this is good. And I just wanted to understand the perspective from the lawyer's side, what is happening.
Oh, I don't think I completely understand your question, but as I said, you know, you really have to look at the composition of the judiciary itself, and some of the ideology of the ruling party has definitely. I can hear them. See, you know, the majoritarian ideology can percolate the judiciary as well, okay? And as I said, that also goes partly to the composition of the judiciary itself. So, if you're going to pack the judiciary with 40% from one community, it definitely leads to a feeling in the judiciary that we can do what we want to do, okay? There is no check over them. So I'm not very sure whether I've understood your question, what you say, why is the judiciary looking at it? For me, the question is, why is the judiciary pronouncing judgments, condemning hate speech, and at the same time appointing people who are known to have, propagated hate speech? That is the question that I was looking at. You know, on the very day when the attack took place within the Jamia University, some of us had filed a petition in the Supreme Court on that same day, and some of the students themselves were petitioners. Now, and that there is one favorite thing that the courts love to do, and they say, why do you file an Article 32 petition, go to the High Court? It happened very. So this is exactly what happened even with the Jamia case. This is also what happened with the Jamia case. Can you hear me? No. Podium and just. So this is also what happened with the Jamia case. That petition was, we were told to go to the High Court. By the time, of course, we went to the High Court, the damage was already done. The case came up before the then Chief Justice of the High Court. The courtroom was packed by students. Maybe some of you were there in the courtroom, and many of us were there arguing on behalf of the students. And the hearing was deliberately prolonged to a point of time when the judges could conveniently get up and say, we have no time now, and come back after 1 week. And this strategy was consistently employed inside the courtroom until we have reached a stage that till today the High Court has not decided. You can remember the petition was filed when the violence was happening in real time. And till today, that case has not been decided. Now, there are many in the High Court. There are many lawyers arguing that case. There are many approaches to the case. But I took an approach, just an approach, saying that you might have the right to stop people from congregating and proceeding towards Parliament House. But what gave you the right to enter the campus? Because the police filed an affidavit in court in which they made a statement that after we declared 144, the crowd dispersed and they did not proceed to Parliament voluntarily. So the legal issue that I raised in the court was, when the crowd has dispersed, when they say we voluntarily will no longer go to Parliament, what gave you the authority to enter inside the university after that? Because they've said it on affidavit that there was no more morcha going to the Parliament. We managed to successfully disperse it. But after that, they entered the university, and that's when those videos which all of you have seen, they beat up. So that is the issue now that I have raised, as I already told you, that most of your constitutional remedies are really ex post facto. No court is willing. It happened in Kanhaiya Kumar's case. Jayaprakash is sitting here at the audience. He's the one who came to me and he said, Ms. Jessing, I was beaten up in Patiala House. And we filed a petition in the Supreme Court under Article 32. And that's when Justice Chalmeshwar appointed a committee consisting of Kapil Sibal and Dushyant Dave, etc., to go and do a survey and come back with a report. And you remember that? So this is it. After the damage is done, only do we get an opportunity to go to court and say, now undo the damage.
So first, I just want to thank you for that really thoughtful lecture, and I learned a lot from it. I had 3 questions. The first was that the Constitution was made perhaps more. Of course, the Congress and people who were involved in the freedom struggle had a major role to play, but the Hindu right, especially K.M. Munshi, was one of the major people who was involved in the making of the Constitution. So in one sense, the Hindu supremacists do not need to repudiate the Constitution because there are many elements in the Constitution which were made at their behest. Second, so in that sense, are we really seeing something that is repudiating or a selective emphasis on certain aspects which were always there in the Constitution, which you pointed to when you said that fundamental duties were being prioritized over fundamental rights? The second question is, when you talk about the idea that people who are interpreting the Constitution are claiming to look at dharma or at a kind of higher sense of ancient Hindu, an ancient Hindu ethos which has informed the Constitution. At one level, one might argue that when it comes to civil law, personal law, judges have always been citing scripture to interpret whether it's temple entry cases or all sorts of personal law cases. It's in the question of constitutional and criminal law that we are now seeing the entry of recourse to kind of religious ethos. So is that again a selective, to say that judges before were not using scriptures and now they begun to use scriptures? Perhaps that's something that one might, I just wanted more clarification on. And the third is that some people, I don't necessarily agree with this, but would argue and have people like Hensky and others argued that even something like PILs as being a uniquely Indian tradition has also looked to Indian traditions where, I mean, of course they don't recognize sort of Mughal traditions of giving instant justice, ringing the bell, etc., but also that you appeal directly to the king for justice or whatever. So I'm just wondering how much this marks a departure from everything that we knew, or it's building upon the more regressive aspects of the Constitution, and in fact, our worry is that we're so busy saving the Constitution today that we will not be able to reclaim it for more progressive ends in future. Thank you.
Okay. So, I should have, before you asked your questions, I should have said to you, any easy questions, I'm willing to answer. But it's too late now for me to tell you that I will only answer easy questions. So now I guess I'm compelled to answer your questions. So the first was, are there any internal provisions in the Constitution which are being used rather than appealing to an external norm? Now, you see, you referred to fundamental duties. Remember that fundamental duties were introduced in the Constitution through an amendment. Okay, they didn't exist in the original Constitution. So, in answer to your question, I would maintain that this is something external to the Constitution that is being invoked now. And it is not my case that this Constitution is the most liberal and the most democratic. But you see, the use of the words in the directive principles of state policy, that they are fundamental to the governance of the state but not enforceable. Okay, that's an important provision that lawyers and judges use all the time. They keep telling you, when you're asking for your economic and social rights, they tell you that the directive principles are not enforceable in a court of law. Go to the political parties and ask for your rights, okay? So, but if you ask whether there was anything, let's take the case of beef ban. And if you ask me the question, was there something intrinsic in the constitution which made Lahoti do what he did? The answer to that is yes. In the directive principles of state policy, there are provisions which say that you shall protect cows. Understood? But the difference between enforceability and non-enforceability was maintained. Okay? They told us that directive principles were not enforceable in a court of law. So what they started doing was enforcing that provision. They relied on that and on the directive and on the fundamental duties. Okay, to that extent, you may argue that they used something that was intrinsic but intrinsically unenforceable. It was a political issue which was converted into a constitutional issue. Now, the next question, which is also linked, is the question of the use of scriptures in personal laws. Now, that's a very different question, okay? And the question there is, you see, there are different meanings attributed to the word personal laws. What is your understanding of quote-unquote personal laws? Very few people have a consensus on this issue. What is the meaning of the expression personal laws? But shorn of all other legalities, it means that the law which will govern marriage, adoption, divorce, custody of children will be the law of the religion to which you belong. Okay? So, and a lot of Muslim law is completely uncodified. If it's uncodified, if the Constitution of India recognizes that uncodified Islamic law, the Sharia, will apply to the Muslims, then so be it. Yes, then they will invoke religion. But it's very different from saying that from saying that you can use any such external laws for anything else. The point is, we accepted a system of personal laws, whether it's Christian, whether it's Hindu, whether it's Muslim. And that controversy now will surface in this new law commission attempt to create a uniform civil code. The real test will come there to see whether they're using external or internal norms to create their UCCs. So I would not like to mix up the issue of use of scriptures when it comes to these laws with the Constitution generally. That's the second answer. And the third answer is, no, the second, continuing with the third answer, the answer is also that, yeah, I think I've done with the second one. So I will maintain that it's extrinsic to the Constitution. I'm not willing, and although, yes, there are, as you rightly point out, in the framing of the Constitution, there are provisions in the Constitution to which they can point to say, look, here are the directions and we're picking it up for them. It's simply not true because those provisions are not enforceable. It's the fundamental rights which are enforceable, and what you see now is a turning on the intellect. Even your fundamental duties are not enforceable in a court of law, but they are treating them now as enforceable in a court of law. So when it comes to PIL, it's abused and so on and so forth. Today, I think it's only the right wing that uses PILs. No one else does. But to give you the origins, your question is, does PIL have a divine origin? The answer is no. It's no. There is no question of appealing to a king for justice when it comes to public interest litigation. Justice Bhagwati, in one of his speeches, he said that the adversarial system of justice is not suited to Indian conditions because of widespread illiteracy, and he said the adversarial system requires self-identification of injury and self-selection of remedies. And he said, no, there's no question that the population of India can self-select their injury or self-identify their injury. They cannot identify a constitutional injury, and they cannot select a constitutional remedy, and therefore people on their behalf are entitled to bring public interest litigation to the court for, and as you know, the earliest public interest litigations were for bonded labor and for those who were working in Asiad and for minimum wages. So I would strongly dispute the proposition that the origins of public interest litigation invoke some kind of residual divine jurisdiction in the judiciary. It's a big procedural breakthrough, but the reasons for that, it's a procedural breakthrough on the question of locus standi. Who is entitled to bring a petition to court? On that issue, it's a very big breakthrough, but it has nothing to do with, it's very much within the four corners of the Constitution.
Good evening to everybody. We are today good in our public discourse, and our protest is less sharp because of the absence of Neelabh Mishra. We need people like Neelabh Mishra always, but at this juncture, when the Republic is facing a huge crisis, we miss him more. I won't say much, I won't take much of your time. I would like to put forward 2 or 3 issues for your consideration. One, the days of one big blow, finishing of the Constitution, are over. Not only in India, but everywhere in the world. Democracies are now dying slowly. Democracies are being killed slowly, imperceptibly. Even those people who are manning, beg your pardon, who are administering the democratic institutions, it could be court, it could be legislatures, it could be ministries, it could be sports federations. They don't realize that around them, those institutions and democratic values are being undermined very slowly and systematically. This is the new reality, and especially this is the reality in New India. This is the kind of crisis that we are facing today in New India. Forget about declared or undeclared. Another thought that I would like to leave with you is there is Professor J.P. Ghosh at the risk of oversimplifying. We have what is something called neoliberal economic theory. Leave the details, but broadly, it tells you that look, let wealth creators be encouraged. Well, wealth creators are encouraged if they're protected. Let them earn a lot of money, let them become rich, and they create employment. They create a lot of job opportunities, and slowly it will trickle down to everyone. And there is a political counterpart to this kind of a philosophy. I'm just leaving this thought with you. That is, are very tolerant. The good people. So don't worry about Hindu Rashtra. Under Hindu Rashtra, every other community is safe. They thrive. So why are you worried about it? So let them put Sengong, let them capture power, let this be declared. Nothing to worry. Tell me, in the entire history, has any Hindu really attack anybody else? No. They are very peaceful, good people. Trust them. Like you trust, our billionaires. Trust them. They're good people. They'll create jobs. They will establish industry. They'll open shops. They'll open malls. They'll open so many things. From 102 billionaires, we have about 145, 150 billionaires today. Nothing wrong is good, isn't it good? Similar. So there is a mirror image of neoliberal and then the kind of New India, the kind of argument that is built. When slavery was, extant, a lot of countries, they really believe that some people are suffering. But when they believe that some people are suffering, could be in the times of Plato, Aristotle, Socrates, and then onwards, until say about middle of the 19th century, 1820s, 1830s. People believe in that ideology. It's the idea. That's very powerful. Similarly, economically, inequality is huge. He's a rich person, will give you something. Why do you want to divide poverty? Let prosperity come about. Don't be jealous of Bill Gates. You also try to become Bill Gates, Jeff Bezos, etc. I don't want to take the Deshi names because I don't want to, make trips to Arunachal Pradesh or Kutch to face defamation cases. So therefore, I'm not taking the Desi names. So there is a belief system. Similarly, a tolerant Hindu Rashtra under which everybody will thrive. And there are a lot of takers to this. There are, if you allow me, Indiraji, I would share two very brief anecdotes with you, my lived experience. When I was coming here from Hyderabad, I came to the airport. I was going through the security. These days, they ask you to take away your waist belt, shoe, anything. And we bag it out. Then there are police personnel who are, overseeing it. Suddenly, I heard one constable say, "One tray, one bag." One tray, one bag, he said. I had a shock. Why is he making a political statement? But apparently it was not a political statement. He wanted one bag and one tray, and I was suddenly reminded of one nation, one tax, all those things. Suddenly, so many other things also came to me. But it was very harmless. He didn't realize. It was my fault. I was overthinking. But that is the kind of crisis we are in. The second lived experience that I would like to share with you is this. Yesterday I shared with my friend Februrary. I recently hired a new driver. My old driver left for a better opportunity. And this boy is hardly 23, 24. Manoj is here. He comes from Rayalaseema. Now, he is new to Hyderabad. He doesn't know the ways. But now you have Google Maps. And Google Maps, in the name of taking you by the shortest route, in the quickest time, it makes you go around in small lanes. So the reason I can drive, the reason that I have a driver is that I can do something else while commuting. So what I do is when I get into the car, I type the destination and Google Maps and give it to him, and it says 600 meters, turn right, etc. This goes on. And during one such trip, it was taking us through very, very small lanes, very narrow lanes. In India, except in, say, a very small area of Newton's Delhi, you don't have really any pavements or walkways. No other city has. Even if you have, we use it for something else, for different things. And when we were going through these very narrow lanes, these lanes are very narrow, people are walking on the road. This boy who comes from Rayalaseema, he turns back and says, "Sir, look at these Muslim fellows. They're walking on the road, they're not letting us go." He is not a person who goes to Shaka. He is not from a place where there are a lot of Muslim population. But it has reached him. This is my lived experience. It has reached him. He said that. Unconsciously said it.
So friends, once more a big hand to Ms. Jai Singh and our chair, and of course thanks to Jawahar Bhavan. For me personally and even politically, I think today became even more significant, because not just that a very, very dear friend, Ms. Jai Singh, was speaking, but she was so erudite and so brilliant that I think that wherever Neelabh be, he would have been listening to it. And we are extremely pleased that Mr. Prabhakar, from his extremely important, I'm sure, agendas, you took out time for this lecture of ours. Thank you so much. I also thank all our friends who come year after year and come to listen to one of Neelabh's friends. We've only had till now, extremely eminent people, and they've been part of the friend circle, and that has been really good. And so when Ms. Jai Singh said that, well, let's break the circuit, let's have somebody, from outside our, fold, and then propose the name. She just read Mr. Parakala's Crooked Timber of New India, said that although what he's saying we all know, but how he said it, and that it is being said once again. And yesterday at the press club, he could fearlessly say it, I think that is the important part, and therefore we are extremely glad, Mr. Prabhakar, that you came, you took out the time, and for your book. Thank you so much. So friends, how do you thank your extremely dear friends? It's always very difficult. They take out the time, and all of you always take out the time. So just some chunnis from Rajasthan is the way we're going to honor them. I request Archana, one of Neelabh's cousins, to help. Ms. Jaising, please select your color. You want a maroon, you want...
Very specific colors.
Okay. And Mr. Prabhakar, would you like to select your color?
I leave it to you.
This one.
Okay, in the meanwhile, there's a bunch of keys that somebody has lost and it's found. Bhasha, we would really like to thank Bhasha, who finally said, yeah, you write friends and family, but some of you appropriate it totally, and I know it. Purvanand, Aruna and me, you know, every year informally just come up. So I'm so glad that Bhasha said, well, this time I'm going to conduct it. More friends, Farah did it once. So more friends, please come forward. Let's take this idea ahead, the values that Neelabh lived for, with more of you participating. It should just be 1, 2, 3, 4 of us. So please, Bhasha. Yeah. This one?
Yeah.
Okay. Thank you, friends.